state of 𝚏𝚗𝚞𝚗𝚊 has violated international law by deliberately concentrated ethnic cleansing, which is a crime against humanity. For this, we make three submissions. If your excellencies may please refer to para 15 of the compromise of the fact sheet. Para 15 of the fact sheet. Much obliged, Your Excellency. In para number 15 of the compromise, it is provided that the 𝚤𝚒𝚗𝚐𝚗𝚊 who are Hindu Brahmins were ousted from the state of 𝚤𝚤𝚗𝚐𝚗𝚊 paradise. Their homes were burned, their dreams were burned. They were internally displaced in their own country, and such a crime can be categorized as an ethnic cleansing. According to the final report of Commission of Experts pursuant to SC Resolution number 780, if Your Excellencies may please refer to page 241 of the compendium, it is provided that ethnic cleansing is an action of rendering an area ethnically or religiously homogeneous by using force or intimidation to remove persons of given groups from the area. In this case, the Hindu Brahmins constituted a minority of 28.43%, and Muslims were in majority, constituting 68.31% of the 𝚤𝚤𝚗𝚐𝚗𝚊 paradise. In this case, only the Hindu Brahmins were ousted from the state of 𝚤𝚤𝚗𝚐𝚗𝚊 paradise, which means that the perpetuators wanted the state of 𝚤𝚤𝚗𝚐𝚗𝚊 paradise to be a religiously homogeneous state. And hence this proves that it was a crime of ethnic cleansing. It can be further categorized as a crime against humanity. If Your Excellencies shall the agent continue?
Yes, please continue.
Much obliged, Your Excellency. If Your Excellencies may please refer to page 229 of the compendium. It is given that under Article 7, Clause 1 of the Rome Statute of 1996, a crime against humanity has been defined as a widespread and systematic attack directed against any civilian population with the knowledge of the attack. Under this article, Clause A, which pertains to forcible deportation, is being satisfied here. The 𝚤𝚤𝚗𝚐𝚗𝚊 Pandits were forcibly deported from the state of 𝚤𝚤𝚗𝚊 paradise, hence constituting a crime against humanity. Also, according to Clause H, which is based on persecution based on religion. So, 𝚤𝚤𝚗𝚗𝚊 Pandits who were Hindus were persecuted based on their religion, and hence it also constituted a crime against humanity. In the case of Karasdik versus Mladi case of the ICTY, it was held that forcible transfer of people also constituted a crime against humanity. In this case, they were the forcible transfer of people since they were intimidated and they were the use of threat and force by burning their homes, which constituted a crime against humanity. Furthermore, Your Excellencies, ethnic cleansing can be categorized as a grave violation of the Genocide Convention. It can be categorized as an act of genocide pursuant to the Genocide Convention of 1948. If Your Excellencies may please refer to Article 2 given on page 137 of the compendium. It is the Article 2 of the Genocide Convention which defines what a genocide act is. So according to that, as per the definition provided in the Genocide Convention, there are three necessary elements which are needed to be proven to constitute a crime of genocide. The first itself is the act. So there was an act of ethnic cleansing. Pursuant to Article 2 Clause B, when there is infliction of serious bodily or mental harm, it is enough to prove the crime of genocide. In this case, there was infliction of mental harm, a grave mental harm, because they were ousted from of their states. Their homes were burned. They had no recourse to any help from the state. In this scenario, they had a very grave mental harm which constituted a crime of genocide. Moreover, pertaining to Article 2, Clause C, it is given that in case of deliberate infliction on group conditions of life calculated to bring about their physical destruction in whole or in part, when the Tikki Pandits were ousted from the state of Tikki Paradise, it constituted such deliberate inflictions on their group as to eliminate them out of the state of Tikki Paradise. And hence, the act element is satisfied. Moving on, the second necessary element is the eliminized or the protected group. So there are certain categories mentioned in the Genocide Convention which pertains to either national, ethnic, racial or religious group. So according to the ICTR, the International Criminal Tribunal for Rwanda, it was said that in the 𝚐𝚗𝚐𝚗𝚘 case, a religious group is a group of whose members share the same religion. In this case, all of the Tikki Pandits were Hindu Brahmins, and hence the victimized or the protected group criteria is also satisfied. Moving on, the third and the last and the most important criteria is the intent or the dolus specialis. A genocide has to be conducted with an intent to be proven as an act of genocide. In this case, according to para 190 in the Bosnian genocide case, the respected ICJ held that if acts of ethnic cleansing occur in parallel to the acts prohibited by Article 2, which is the act of genocide, they are significant and as being indicative of the presence of specific intent. So the crime of ethnic cleansing is committed with an intent to render that area homogeneous. And in this case, this intent can be taken as an intent to commit genocide. In the present scenario, according to para 19 of the compromise, the NHRC found around 2,000 unmarked graves across the LOC. In this case, this is a serious violation of the Geneva Conventions, which are also the customary international law, since these graves were not properly buried, they were unmarked. There was no identification of the victims, there was no proper burial, and the relatives of the dead families were not informed of their deaths, and they did not have the right to perform the last religious rites of the dead people. And hence, in all of these scenarios, there is a grave violation of international humanitarian law. If Your Excellencies are satisfied, the agent would begin with the last issue. The last issue, which pertains to that the Republic of 𝚏𝚗𝚞 should conduct a fair and impartial plebiscite in order to make realize the people of Tikki Paradise their right to self-determination. In this regard, we say that the state of 𝚏𝚗𝚞 has failed to honor their UN resolution. In 1948, the UNSC mandated a plebiscite in pursuance of Article 25 of the UN Charter. According to the Article 25 of the UN Charter, every member of the United Nations who ratified the UN Charter has to comply with the UNSC resolutions, which was not done in this case. Moreover, the ICJ, in the Namibian advisory opinion, held that a UNSC resolution would be binding if the language, discussion preceding the passage of resolution indicated that it was binding. And the United Nations presence in the area since 1948 shows the commitment of the United Nations to solve the issue of the Tikki Paradise. And hence, this UNSC resolution should have been followed, and the plebiscite should have been conducted by the state of 𝚏𝚗𝚞, which it was not. And this resulted in a grave violation of their right to self-determination, which is an ergo omnes obligation, as already proven. According to the, as my co-agent has already dealt with, the right to self-determination is the right of people. And in this case, in all the scenarios, when the IOA was signed, when the Constituent Assembly for the state of Kashmir was formulated, and when the 370 was repealed, in none of these cases, there was any will of the people that was asked. So the will of the people was never considered. And hence it is contended that the non-pursual of the UNSC resolution, which mandated a plebiscite, and there was no plebiscite conducted, this resulted in the violation of their right to self-determination. This is all that we submit from the side of the
elements that you have argued.
Yes, Your Excellency.
What is the material and available before you to have a locus that there is a genocide by 𝚏𝚗𝚞, whether it's by army or any ethnic group? The exodus of Tikki Pandits, have they complained to you about any genocide? What is the evidence and material apart from the graves that we have found as per the report of the International Human Rights Commission? What is the material before you?
Your Excellency, the ousting of Dikki Pandits is a conclusive evidence because it has been provided in the fact sheet.
What is the cause? You say that's a genocide. How do you say that the 𝚏𝚗𝚞𝚗𝚊 state is involved in that?
Yes, Your Excellency. So in this case, the genocide was conducted by an armed outfit known as Plebiscite and Dikki Freedom League. But the state of Dikki Paradise, the state of 𝚏𝚗𝚞𝚗 is responsible, and this act will be attributable to the state since it failed to prevent and punish the crime of genocide. If Your Excellencies refer to the case of Bosnian genocide. In this case, the ICJ acquitted Serbia for committing of genocide, but genocide in the Bosnia and Herzegovina during the Balkan Wars of 1990s. But it proved that the state of Serbia was guilty of failing to prevent the genocide. And in similar manner, we say that the state of 𝚏𝚗𝚞𝚗 will be liable and in violation of the Genocide Convention since it failed to prevent and punish those who had perpetuated such a grave commission of genocide.
Let me just ask you one question.
Yes.
So you have essentially come here to this forum because 370 was abrogated.
Yes.
Now, how do you get over while doing that, you are also raising the question which happened in genocide and ethnical cleansing in, you said in 89, right? 99. So how do you explain the delay? Why are you raising it now? How come you did not invoke the jurisdiction then?
Your Excellency, we come before this court because, and we try to prove that there have been a consistent pattern of the grave human rights violations since a long period of time.
So there is no, sorry to interrupt you. So there is no intervening incident from the genocide, ethnical cleansing and the 370. So I'm just asking you to explain the delay.
Your Excellencies, we had, before coming to the ICJ, we had gone to the United Nations Security Council. We had tried to hold negotiations with the state of 𝚏𝚗𝚞𝚗𝚗, but these negotiations failed and the UNSC refused to hear our matter on this case. And as a last resort, we had to come to the ICJ because we do care of these grave human rights violations which have been taking place in the Dikki Paradise for over past 50 years. And all of this combined, we say that the state of Martini comes before the ICJ to protect the rights of the people, since these human rights violations have been living in the constant fear and terror of these human rights violations since a very long period of time.
All right, thank you.
You said that mental insult will also tantamount to genocide.
Mental harm.
Mental harm.
Yes,
mental harm. So, do you mean to say that is it a punishable one? Mental insult, if tantamounts to genocide, is also a punishable offense.
Your Excellency, it is one of the parts to constitute the act of genocide. And if a mental harm,
So, one element of constituting genocide.
Yes, Your
It can
Excellency.
only be said like that. So, it cannot be said to be a genocide, but it can be an element constituting genocide.
Yes, Your Excellency.
A very simple
Yes.
question to you. The genesis of your allegations against the respondent state is the repealing of Article 370, which, as per your allegation, has resulted into the violation of many human rights which are recognized by the international law,
Yes,
and genocide is one of them. You referred certain articles of the convention, treaties, few case law, but where are the evidences? You just referred one report of National Human Rights Commission that 2,000 graves were found, unmarked graves were found along the line of control. But where is the source of your evidence, information regarding the alleged violation of international human rights law by the respondent? Because if your allegations are proved, these allegations are, connects with serious international ramifications against the respondent state. So you have to stand upon your own legs. Allegations must be substantiated by authenticated evidence and document. And I think your evidence part is missing.
Your Excellency, the fact sheet can be taken as conclusive evidence because these are proven facts. In case of
How you can say these are the proven facts?
Your Excellency, since it is given in the fact sheet, so we have to make our case on the same matter, and hence we have to take them as evidence to prove our case.
There's one more question.
Yes, Your Excellency.
You talked about the plebiscite and the UN resolution because the Latini state approached the United Nations.
Yes, Your Excellency.
Now, you have not discussed it. What exactly were the conditions for the plebiscite and how far you discharge your obligations?
Your Excellency, that is a very pertinent
Because it didn't
observation.
take place.
Yes, Your Excellency. So the condition precedent to the commission of the plebiscite was that both the nations should agree to demilitarize the region. To have a stable, there has to be stable peace. But in pursuance of our obligation, we did hold negotiations with the state of Latini. But since the state of Latini did not agree to demilitarize the area, we could not have done anything and the negotiations failed. So in this case, we say that the onus of demilitarizing the region of the Ṱikiṭiki paradise, since the Ṱikiṭiki paradise was in control of the state of Latini at that moment of time, lies with the respondents and not with the applicants.
Thank you.
Just very simple. You are seeking the referendum or plebiscite for the people of Ṱikiṭiki paradise. But in present scenario, whether this demand or this you can say request in a more positive word or polite word, still it is justified demand to hold referendum or plebiscite. The much water has flown. What is appearing from the facts and your testimonials, that is since 1947 when that Ṱikiṭiki faced some aggression from external forces, and now this is too.
Time to answer the question.
Just 1 minute answer.
Sure, Your Excellency. If we were to consider the will of the people of the state of Ṱikiṭiki paradise, we see that since 1948, there have been a lot of protests against the government of Ṱikiṭiki paradise and the state of Latini. There have been a lot of separatist movements. There has been a lot of want for plebiscite in the state of Ṱikiṭiki paradise, which essentially shows that the people do want a plebiscite. They do want a say in how they want to be governed. And in a similar fashion, we say that the electing of democratic governments is not cannot be said to be a fulfillment of the right to self-determination, because what if the people of Ṱikiṭiki paradise want to accede to the state of Martin?
Shall be representing the respondent, the Republic of Latini, in the case concerning the Ṱikiṭiki paradise, hereinafter referred to as the DDP. I shall be arguing for 20 minutes today and will consider issues 1. I hope I'm audible now. I shall be arguing for 20 minutes today and will consider issues 1 to 4. Subsequently, my co-agent shall also argue for 20 minutes and will consider issues 5 to 7. We respectfully reserve 5 minutes for our sir rebuttals. If your excellencies have no preliminary queries, I seek permission to proceed. Your excellencies, the agent seeks permission to refer to the facts as and when they are relevant to the issues at hand, looking at the paucity of the time that we have. Thank you. Much obliged, your excellencies. The first issue deals with whether the repeal of Article 370 has led to the violation of any international human rights. It is contended that the repeal of Article 370 was not a violation of human rights. Rather, it was a necessary step for the promotion of good governance in DDP and to promote social justice and economic development. This would be further contended on 2 prongs. A, the Republic of Latini has the responsibility to promote social and economic well-being of DDP, and B, Article 370 was a hindrance in the realization of these goals. Considering the first prong of the argument today, your excellencies, it is submitted that it is the responsibility of a state to protect its citizens and ensure that there is no discrimination and complete economic development of a region within it. Further, Article 2, Clause 1 of the International Covenant on Economic, Social and Cultural Rights necessitates it for a state to undertake steps to realize the rights that are given under the covenant, particularly through legislative means. 𝚁𝚗𝚞𝚗𝚐𝚑, being a signatory to the ICSCR, is obligated to follow this. DDP is an integral part of the state of 𝚁𝚗𝚞𝚗, as has been stipulated in the constitutions of both 𝚁𝚗𝚞𝚗 as well as DDP. Therefore, it is the responsibility of the state of 𝚁𝚗𝚞𝚗 to undertake steps in order to ensure the well-being and fuller realization of the economic, social and cultural rights of the people of DDP. Further, on the second prong of the argument, Your Excellencies, it is submitted that Article 370 was rather a hindrance in the realization of these goals. As per this article, the government of 𝚁𝚗𝚞𝚗 could not legislate on certain core areas for the state. The provisions of the Constitution of 𝚁𝚗𝚞𝚗 and most other laws of the state of the Republic of 𝚁𝚗𝚞𝚗 were not applicable in the region by virtue of this article. Thus, the people of the region could not enjoy the rights and the freedoms which were enshrined in the Constitution of 𝚁𝚗𝚗𝚗 and which were also extended to all the other citizens of the country, while the people of DDP being an integral part of the Republic of 𝚁𝚗𝚗 and its people being the citizens of 𝚁𝚗𝚗 could not enjoy those rights as well. There were instances of corruption and breakdown of constitutional machinery in the state of DDP. This hindered their right to live peacefully. Hence, it was considered essential that the entirety of the provisions of the Constitution of 𝚁𝚗𝚗 be made applicable to DDP, so that the said region and its people may enjoy the full protection of all the provisions of the 𝚁𝚗𝚗 Constitution, as well as the civil and penal welfare legislations which are enforced in the Republic of 𝚁𝚗𝚗. Your Excellencies, coming on to the next issue. The next issue deals with whether the Republic of 𝚁𝚗𝚗 has terminated its treaty obligations under the instrument of accession. Before proceeding with our arguments, Your Excellencies, we would like to question the admissibility of this claim from the side of the applicant. An instrument of accession is in the nature of a treaty between two sovereign states. It is not a convention or a general treaty which is applicable to states at large. It is a treaty between two sovereign states, and third parties cannot interfere with this treaty. If facts do not allow for a deduction that there is a direct impact which happens on a state which affects the rights of a state, a third party cannot sign between two states. This was held by this court itself in the case of Greece versus Britain. In the present circumstances, the Islamic Republic of Martini does not have any locus to bring an action because neither was protection of the state of 𝚁𝚗𝚗𝚗. It is important to note that over the course of time, the situation in this region, rather than getting mitigated, has rather been aggravated. There is an ever-present terrorist threat in the region. The militancy has been on an ever increase. Further measures in order to strengthen the security of the region. Your Excellencies, it is an important point to consider that states must uphold the essence of a treaty. The essence of the instrument of accession, the reason why the instrument of accession was signed was essentially to protect the people of DDP, to protect them from any sort of violations and armed conflicts which were furthered by the armed tribesmen from Martini at that point of time. Therefore, it is the obligation of the state of 𝚁𝚗𝚗𝚗 to protect the people of DDP and undertake all the measures that would be necessary in order to secure this goal. Thus, the Act of Abrogation of Article 370 was not in derogation of the instrument of accession. Rather, it was a necessary, as has been previously established, it was a necessary step in order to counter the growing militancy and terrorism in the region. Your Excellencies, moving on to the third issue, it deals with whether the state of 𝚁𝚗𝚗𝚗 has denied to the people of DDP their basic and fundamental right to self-determination. It is contended that 𝚁𝚗𝚗𝚗 has not denied to the people of DDP their right to self-determination. Instead, it has helped people live their lives freely. The claim of the Islamic Republic of Martini that the fundamental right to self-determination has been violated is unfounded. This would be argued on two prongs. A, the principle of territorial integrity has to be respected, and B, the measures that are undertaken by the Republic of Flirtini were to help the people of DDP to live their lives free. Territorial integrity imposes limitations on self-determination, as has been held in the case concerning the frontier dispute between Burkina Faso versus Mali by this court itself. The purpose of the latter is to protect territorial integrity and stability of independent states. The exercise of self-determination must be limited to prevent threats to an existing state's territorial integrity. This was the observation of the Canadian courts in the question of secession of Quebec. Self-determination does not authorize an action that dismembers or impairs the territorial integrity of sovereign states. There also exists no unilateral right to secession. Any right to self-determination has to be exercised under the parent state's constitutional system itself and based on the respect for its territorial integrity and national sovereignty. DDP is an integral part of the Republic of Flirtini. The constitution adopted by DDP also declared that it is an integral and inseparable part of the Republic of Flirtini. The right to self-determination cannot be exerted in a way that would threaten the integrity of the Republic of Flirtini. There were secessionist movements in DDP which compelled the government of Flirtini to take measures that were necessary to protect state sovereignty and national unity. Furthermore, it is submitted that the measures were undertaken to help the people of DDP live their lives freely. As per Article 3 of the UDHR, every individual has the right to live, to be free and to feel safe. It is the responsibility of the states to protect its people and ensure that they are allowed to exercise the very basic of rights of living freely and in a safe environment. The responsibility to protect endows a state with great discretion to take measures that might otherwise violate international legal standards, but the duty to prevent and halt atrocities and human rights violations lies first and foremost with the state. Therefore, the people of DDP, who had been living in very dire circumstances with terror attacks and other violent clashes between secessionists and the army, the people had been living under a constant fear, and the basic right to live without fear of getting bombarded at any point of time in their lives or being attacked by a terrorist or a militant outfit was violated. They could not live with the basic human dignity and the basic security of life. Therefore, the risk of atrocity in the region was high enough to justify the measures undertaken by Flirtini to protect the peace and security of the region and ensure that the people of the region lived their lives freely without fear. Further, the agents for this applicant had mentioned about the United Nations resolution which had mandated, which according to the agent for the applicant, which was binding on the state of Flirtini for conduction of a plebiscite. It is important to note that the resolution had put forth certain conditions. Those conditions, it was an obligation as per the resolution itself that the Republic of Martini, the resolution had created the obligation on the Republic of Martini to demilitarize the region, to ensure that there is to ensure that all the armed tribesmen who had infiltrated the region of DDP have ceased to be there, and only then, if these conditions were met, only then would the obligation on the state of Flirtini arise to carry out a plebiscite. It is submitted before the court that this was not ensured. Nowhere has it been given in the factual matrix that the state of Martini had ensured that the armed tribesmen had ceased to be in the state of in Diki Paradise, and therefore it had not fulfilled its own obligations that were given under the resolution, and it cannot invoke the bindingness of the resolution on the state of Flirtini. Moving on to the fourth issue, it asks whether the repeal of Article 370 is an internal affair of the Republic of Flirtini and the customary norm of non-intervention applies to the state of Martini and all other states or not. Your Excellencies, it is contended that the matter of DDP is an internal affair of the Republic of Flirtini, and any interference from Islamic Republic of Martini or any other states is a violation of the customary norm of non-intervention. Your Excellencies, this would again be argued on two facets. A, that DDP is an integral part of the Republic of 𝚤𝚗𝚗𝚗, and interference from other states would violate the principle of territorial integrity. And B, the interference of the Islamic Republic of 𝚤𝚗𝚗𝚗 violates the norm of non-intervention. It is submitted before the court that the creation of a new state to the domain of is the domain of the domestic law of the existing state, while the seceding entity presently forms a part of. The principle of non-intervention imposes on third states the obligation not to support any secessionist claims. The right of national liberation movements to seek outside support has been recognized, but that has been recognized only in the context of colonial or alien domination. In all other cases, states are required to strictly observe the territorial integrity of the parent state. Every state shall refrain from any action that is aimed at the partial or total disruption of the national unity and territorial integrity of any other state. This was declared in the Colonial People's Declaration in paragraph 6. Your Excellencies, it is submitted, as has been stipulated earlier, DDP is an integral part of the Republic of 𝚤𝚗𝚗𝚗. The Islamic Republic of 𝚤𝚗𝚗𝚗 has given support to the secessionists in the DDP region, as has been mentioned in the factual matrix, paragraph 14. And the state of 𝚤𝚗𝚗𝚗 has been providing assistance to these forces, which might create conditions for dismemberment of the state. These forces have been asking for secession from the state of 𝚤𝚗𝚗𝚗, and this would lead to the dismemberment of the state, which violates the principle of territorial integrity of the state. The state of 𝚤𝚗𝚗𝚗 has failed to respect the territorial integrity of the Republic of 𝚤𝚗𝚗𝚗. Thus, there has been a breach of its international obligations, as the matter of DDP is an internal matter of the Republic of 𝚤𝚗𝚗𝚗, and the intervention is a violation of international norms. The other facet of this argument is that the intervention of the state of 𝚤𝚗𝚗𝚗 violates the norm of non-intervention. The principle of non-intervention is a well-recognized custom in international legal arena. Intervention in any form, be it economic, political or other, directly or indirectly manifested, is prohibited. It is permissible only upon the invitation of the government of the state itself, while intervention in support of the opposition and secessionist movements threatens not only the sanctity of the principle of non-intervention, but the international legal order at large. DDP, being an integral part of the Republic of 𝚤𝚗𝚗𝚗 and the instrument of accession, which was signed between the ruler of DDP at that time and the Republic of 𝚤𝚗𝚗𝚗, makes it a part of the 𝚤𝚗𝚗𝚗 government, makes it a part of the state of 𝚤𝚗𝚗𝚗 itself, and therefore DDP cannot in any way, therefore 𝚤𝚗𝚗𝚗𝚗 cannot in any way interfere into the affairs, because clearly, as has been mentioned before in all the other issues as well, the state of DDP is an integral and inseparable part of 𝚤𝚗𝚗𝚗. With this, I would rest my submissions if Your Excellencies would have any questions.
So one question I want to put to you is, see, you said that the state of 𝚤𝚗𝚗𝚗 has not violated anything by cancelling the settlement of accession. So it's a it's a unilateral act. Is it so? See, an agreement is a result of a consensus. So settlement of accession has been entered into out of consensus between two states. Then it was cancelled unilaterally. So you mean to say that state of 𝚤𝚗𝚗𝚗𝚗 is justified in cancelling the settlement of accession by doing it unilaterally?
Your Excellency.
So all the internet facility, the access to media, everything were cut all on a sudden. So do you mean to say that the rights of the people have not been violated by cancellation of the settlement of accession?
Your Excellencies, the point about violation of the rights of the people would be taken up by my co-agent, but I would like to point it out here that there can be imposed certain reasonable restrictions when it is necessary, and my co-agent would go on further.
So my question is whether it can be done unilaterally.
The termination of the treaty on part of the Republic of 𝚤𝚏𝚗𝚘𝚞𝚗𝚍, it is important to note the Article 62 of the VCLT, which talks about a fundamental change in circumstances, which might a fundamental change in circumstances when that has happened, it is not obligatory on the parties who are signatory to the treaty to uphold its obligations. This principle of rebus sic stantibus is an exception to the principle of pacta sunt servanda, and therefore this unilateral violation was not in violation of the international norms because there was a fundamental change in the circumstances and it was necessary in order to protect the people of India. Yes.
One question I want to ask that
Your
for
Excellency, the time is over.
can I put a question? You took the ground of good governance and economic development to repeal Article 370. You admit that the instrument of succession resulted in the merger of 𝚤𝚑𝚗𝚐𝚗𝚘𝚗 paradise with your 𝚤𝚤𝚗𝚗 dominion. Then how far for the last so many years, 70 years, you have not been able to develop because it was all your merger and in a merged state? Then what's the occasion to repeal 370? You always send your military to the area. Many a times you had a president rule in the 𝚤𝚑𝚗𝚗𝚗𝚗 paradise. So how do you say this? What is the basis of your argument?
Your Excellencies, two things are to be noted here, as was also argued by me in the submissions, that Article 370 essentially was a hindrance in this, in the realization of these goals. Article 370 did not let the government of 𝚤𝚑𝚗𝚗𝚗 legislate on certain matters, which were certain core areas of for development of the region. Which were certain core areas for which would lead to legislations which would further the interests of economic development and social justice. But Article 370 proved a hindrance proved as a hindrance in the realization of these goals. Further, the merger, as you had mentioned, that there had been certain instances of presidential order, president's rule on the state as well. It is important to note the circumstances which prevail in the state. The state has been under a constant threat of terrorists. The state is not under peaceful circumstances. It has not been so. I would seek an extension.
No, it's very another question, very simple question. You know that 𝚤𝚑𝚗𝚗𝚗𝚗𝚗 and 𝚤𝚑𝚗𝚗𝚗𝚗 paradise had never been the part of your state, respondent state. Its accession was outcome of the certain promises made by you to the people of 𝚤𝚑𝚗𝚗𝚗𝚗 and the then ruler of the 𝚤𝚑𝚗𝚗𝚗. And out of that, the right of self-determination was one of them. You unilaterally cancelled the instrument of succession. You denied the right of plebiscite despite the promises made in United Nations without any justification, and the justification given by you, the respondent state, whether they have been accepted by the international community or not. Like your growth, development, it means there was no growth and development before the repealing of Article 370 in 𝚤𝚑𝚗𝚗𝚗𝚗 paradise. Where are the international justification of your act? Rather, the sir has said unilateral act.
Your Excellencies, it is important to note that though the people of DDP had been promised at the signing of the instrument of accession that they would be given their right to self-determination, and nowhere does the Republic of 𝚤𝚏𝚗𝚗𝚗𝚗 oppose this claim. It was the Republic of 𝚤𝚏𝚗𝚗𝚗𝚗 itself who had gone to the UN in 1948, as has been mentioned in the fact sheet, in order to settle the disputes which were there between the Republic of 𝚤𝚏𝚗𝚗𝚗𝚗 and Martini. It was the Republic of 𝚤𝚏𝚗𝚗𝚗𝚗 itself who had gone there, and it following this, the United Nations had passed the resolution for the referendum. It is very well acknowledged that it is very well acknowledged, as has also been mentioned by me in one of the contentions, that the resolution had essentially mandated it for Martini to fulfill its obligations, and only then could the obligation to facilitate a plebiscite on Flirtini would arise. There had to be circumstances which would lead to a fair and impartial plebiscite. It is contended that these circumstances did not arise because Martini had been supporting. If Your Excellencies have no further queries, my co is including.
Greetings to Your Excellencies. Before the occasion begins, she would like to apologize in advance for any waver in her voice during the speech, as she is suffering from a bad case of sore throat. Moving on, the agent would be dealing with the further issues that have been brought up in this dispute. And the first issue that will be dealt by the agent is the one whether Flirtini has committed an international wrongful act as being claimed by the agents of the applicant. The agents of the applicant have stated that in order to establish a state having committed an international wrongful act, two essentials have to be met with. First, there has to be attribution to the state, which is to whom the obligation is being linked, and second, there has to be a breach of an international obligation. For this issue, the agent will be dealing with three separate prongs. In the first prong, she will be discussing how international human rights laws as given under the ICCPR have not been violated by Flirtini. Moving on, she will be dealing with the allegations of ethnic cleansing and genocide that have been leveled against the respondent by the applicant side. And lastly, she will be dealing with the obligation that the applicant side is enforcing with regards to international humanitarian law, which is allegedly applicable in the particular situation. Moving on to the first prong of the argument. It is contended, firstly, that the right to freedom of movement of the people of DDP was restricted in the interest of national security of Flirtini. Secondly, that the internet and mobile services were curtailed with the aim of inhibiting communication among militant outfits. And lastly, that the leaders of DDP were detained on reasonable grounds and there was no violation of personal liberty. For the first argument, it is put forward that the right to freedom of movement of the people of DDP was restricted in the interest of national security. Article 12 of the ICCPR, which creates an obligation on the state of Flirtini in the first place, also provides certain restrictions. The general commentary to the article, as well as the landmark case of Nicaragua in paragraph 270, provides that the right to freedom of movement can be restricted to preserve national security, especially when the restriction is proportional, appropriate to achieve its protective functions, and precise and with a legal basis. It is submitted to Your Excellencies that the national security of Flirtini was threatened by the increasing terrorist activities of militant groups in Ticketing Paradise. As a sovereign state, Flirtini has the right to protect its own people and its own territorial integrity. The restrictions that were set by Flirtini on the freedom of movement of the people was proportional, as it is to be noted that there was no blanket curfew on the movement of people. The facts clearly provide in paragraph 22 of the compromise that only a gathering of more than 4 people in public spaces was imposed. So we see that this was not the most intrusive action that was available to the applicant in the first place. Moreover, the same was based on existing domestic laws and was the least, as argued, the least intrusive course of action to achieve its protective function. Therefore, there was no violation of the right to freedom of movement. Moving on to the second argument, internet and mobile services were curtailed to inhibit communication among militant outfits. It is submitted to the court that Article 19 of the ICCPR allows the right to freedom of speech and expression to be restricted to preserve national security. And as mentioned in the last argument, the landmark case of Nicaragua, as well as the general commentary, again prescribe that the restrictions should be proportional and should be reasonable to achieve protective functions. Moreover, in the Human Rights Committee case of Shin versus Republic of Korea, it was held that states are required to establish a direct and immediate connection between expression and the threat. It is submitted by the agent that all of these requirements were met in this particular situation. Militant groups were carrying out terrorist activities and indoctrinating the youth of 𝚁𝚗𝚞𝚗𝚊𝚕 paradise to such an extent that they were engaging in clashes with the troops. They were spreading secessionist propaganda. This actively and aggressively threatened the national security of Lohri. Considering that the militant groups were able to achieve the same because of the communication system that existed between them, it therefore became essential that the mobile services and the internet services were to be curtailed since there existed a direct connection between the expression and the threat that 𝚁𝚗𝚞𝚗𝚊𝚕 was faced with. Therefore, it is contended that restrictions imposed by 𝚁𝚗𝚞𝚗𝚊𝚕 were appropriate to carry out its protective functions. Moving on to the third argument, the leaders of 𝚁𝚗𝚞𝚗𝚊𝚕 paradise were detained on reasonable grounds. It is submitted before the court that according to Article 9 of the ICCPR, deprivation to liberty can happen on substantive grounds and procedure as are established by law in a clear and prescribed manner. The general commentary to the same article provides that a detention has to be proportionate and states have to justify that no other alternate course of action existed. According to paragraph 21 of the compromise, 𝚁𝚗𝚞𝚗𝚊𝚕 paradise had been under the centre's regime since 2018, and later the Legislative Assembly of the state was also dissolved. This was a source of political friction, and because of the same, the political leaders posed a threat to 𝚁𝚗𝚞𝚗𝚊𝚕 as they had the potential to cause further civil unrest by instigating and mobilizing the people of 𝚁𝚗𝚞𝚗𝚊𝚕 paradise. Such an occurrence would lead to direct and immediate threat to the national security as well as the public order of 𝚁𝚗𝚞𝚗𝚊𝚕, and hence no other alternative course of action existed given the circumstances. Moving on to the second prong of the argument, if there are any questions the agent would like to ask. Much obliged. For the second prong of the argument, there have been claims of ethnic cleansing alleged by the agents of the applicant. The claim relates to the exodus of Diggy Pandits, and the applicants have claimed that ethnic cleansing had been carried out to such an extent that the same qualifies as a crime against humanity given under Rome Statute, and the same also qualifies as a genocide. However, the agent would like to point out that throughout their lengthy argument, they did not focus on one very essential aspect. Who were the ones who carried out the ethnic cleansing? Who were the ones who carried out the genocide? Since the matter relates to the Diggy Pandits, the agent requests Your Excellencies to refer to paragraph 15 of the compromise. Paragraph 15 of the compromise clearly mentions the plebiscite and 𝚁𝚗𝚞𝚗𝚊𝚕 Freedom League were gaining strength and were instrumental in ousting the Diggy Pandits, Hindu Brahmins, who were compelled to flee their hometowns in face of the rising militancy that burnt not just their homes but their dreams as well. Again, the agent would like to draw the attention of Your Excellencies to paragraph 14 of the compromise, where it states that Martini supported PDDFL, which is the militant outfit in question, through backdoor and itself incited terror attacks and demand for a plebiscite. Here in this situation, we see that Martini is now trying to hold 𝚁𝚗𝚞𝚗𝚊𝚕 responsible for an act that it itself caused. Here, the application of doctrine of clean hands will apply. According to the landmark case of Nicaragua, in paragraphs 268 and 273, the doctrine of clean hands was propounded, and it says that the states cannot have locus standi to file a claim before a court if they themselves were guilty of an illicit conduct. Here we clearly see that firstly Martini supported militant outfits, the militant outfits carried out the ethnic cleansing, and now Martini wants to claim that 𝚁𝚗𝚞𝚗𝚊𝚕 should be held responsible for the same, given that they were the one who caused the entire chain of action of the ethnic cleansing. Moreover, Martini, since it has been proved, since it will also be later proved that by supporting these subversive outfits, it has violated the principle of non-intervention, and this in itself is an international obligation that it has violated, and it can be held that Martini is in violation of has committed an international wrongful act. Moreover, moving to the point of the international humanitarian law. the agents of the applicant have contended that 𝚁𝚗𝚞𝚗𝚊 has violated international humanitarian law. However, they have failed to establish that international humanitarian law will be applicable in the dispute of 𝚁𝚗𝚞𝚗𝚊 paradise in the first place. As is required for the application of the law, first it has to be proved whether the armed conflict was either an international one or a non-international armed conflict. They have relied on Geneva Convention first 3 and 4. However, it must be noted by your excellencies that the conventions only apply in the cases of international armed conflicts. Since this entire dispute relates to the 2000 unmarked graves which were found near the LOC, at the LOC where there were disputes happening between the Mauritanian troops as well as the 𝚁𝚗𝚞𝚗𝚗𝚗 troops, it is contended that if the applicants are claiming that an international armed conflict did take place, and if they're alleging that 𝚁𝚗𝚞𝚗𝚗𝚗 was one of those parties, then automatically Mauritania also becomes one of the parties, and then Mauritania is also held responsible for the obligations that it is now trying to impose on 𝚁𝚗𝚞𝚗𝚗𝚗 itself. Moreover, if they claim that it was a non-international armed conflict, they have not been able to establish that it meets the two triggering requirements of that being the violence being a protracted one, as well as there being enough coordination as well as structure in the other non-state group to for it to be a non-international armed conflict. Therefore, they have not been able to establish obligation of 𝚁𝚗𝚞𝚗𝚗𝚗𝚗 in this particular case as well. If your excellencies do not have any questions with regard to this issue, I will move on to the next issue. For the next issue, it is contended that Mauritania has violated international law by unnecessarily violating the principles of non-intervention and by defaming 𝚁𝚗𝚞𝚗𝚗𝚗 in international circles. The same will be argued on 3 fronts. Firstly, Mauritania has no locus to seek intervention on the ground of humanitarian intervention. Secondly, Mauritania has unnecessarily intervened in the domestic affairs of 𝚁𝚗𝚞𝚗𝚗𝚗𝚗. And lastly, that Mauritania defamed 𝚁𝚗𝚞𝚗𝚗𝚗𝚗 in international circles. For the first prong of the argument, it is submitted that Mauritania has no locus to seek intervention on the ground of humanitarian intervention, and 3 arguments are provided for the same. Firstly, General Assembly resolutions on non-intervention require that states should not be chasing their own vested self-interest while intervening in the matter of another state, and should only be motivated by preservation of human rights alone. As has been argued in the previous issues, Mauritania itself was committing human rights violations inside 𝚁𝚗𝚞𝚗𝚗𝚗𝚗. Moreover, it is argued that Mauritania has vested interest in the dispute, as it has itself been trying to increase the land under its control, as is evidenced by how it has not respected the geographical delineation of either 𝚁𝚗𝚞𝚗𝚗𝚗𝚗 paradise or 𝚁𝚗𝚞𝚗𝚗𝚗𝚗 since 1947, as is evidenced by paragraph 8 of the compromise. The second argument put forward is that states can be precluded from claiming humanitarian intervention when they themselves contribute to human rights violation. Here the doctrine, the clean hands doctrine, as was earlier discussed by the agent, would again come into application, and it would once again prove that the clean hands doctrine requires that states cannot have a locus standi to file a claim before a court if they themselves were guilty of illicit conduct. And by supporting militant groups to encourage secessionist propaganda and to carry out terrorist activities and to carry out, as they themselves claim, ethnic cleansing within the territories of another state, Mauritania is guilty of illicit conduct, which precludes Mauritania from claiming humanitarian intervention. And lastly, Mauritania has not acted in good faith. The preamble of the UN Charter specifies that good faith fulfill their obligation in reasonable ways. However, Mauritania constantly threatens the territorial integrity and political independence of 𝚁𝚗𝚞𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗𝚗 For the second prong of this argument, it is submitted that Martini unnecessarily intervened in the domestic affairs of flirting. According to the Friendly Relations Declaration, principle of non-intervention is a customary international law and it prohibits intervention in any form, be it direct or indirectly manifested. In the case of Nicaragua, in paragraph 246, it was held that support to secessionist movements threatens the principle of non-intervention and the international legal order at large. Martini's support for militant groups in Tiki-Tiki Paradise, as is evidenced by paragraph 14 of the compromise, is an illegal act of intervention as it violates the principle of non-intervention. Moreover, the decision of Flirtini to abrogate Article 370 is a domain reserve concern as it is related to the internal political order of Flirtini. since paragraph 11 and 12 of the compromise already make it clear that DDP is an integral part of 𝚁𝚗𝚞, and therefore this decision is fairly under the jurisdiction of 𝚁𝚗𝚞. For the third prong of the argument, it is submitted that Martini defamed 𝚁𝚗𝚞 in international circles. UN condemns all forms of overt, subtle, and highly sophisticated techniques of defamation aimed at disrupting the political, social, or even economic order of other states. The claims that have been put forward by the applicant tarnish the reputation of 𝚁𝚗𝚞 as they lay false accusations and needlessly sensationalize domestic matters. The claims seek to destabilize 𝚁𝚗𝚞 are in pursuit of Martini's own vested interests. If Your Excellencies do not have any question, the agent seeks to the next issue. Correct? Moving on to the last issue, Martini has violated international law by illegally and maliciously pelting stone over the territorial integrity and political independence of 𝚁𝚗𝚞. It is submitted that the principle of territorial integrity and political independence, as has been enshrined under Article 2 of the UN Charter, was declared to be customary in nature in the case of Kosovo in paragraph 18. And it has also been declared to be inviolable by the Friendly Relations Declaration in Article 6. States have a duty, therefore, to protect the territorial composition of other states by respecting and recognizing their geographical delineation. Numerous Security Council resolutions, as has been mentioned in our written submission in footnote 99, hold that support or encouragement of secessionist movements by one and carried out terrorist activities. Such acts amount to coercive acts which illegally and maliciously threaten the territorial integrity and political independence of 𝚁𝚗𝚞. The agent rests her submission.
I'll just ask you one question. You said that you kept blaming the state of Martini for actually committing and encouraging the ethnical cleansing issue back then. But then, is it not your responsibility, since you claim it is your state, to take action against stopping the atrocities and violation of human rights? What have you done?
The ethnic cleansing that has been referred to by the applicant is that which relates to the Dicky Pandits. After the exodus of the Dicky Pandits happened, the 𝚁𝚗𝚞 made sure, as is evidenced by paragraph 15 of the compromise, that 𝚁𝚗𝚞 government imposed the Armed Forces Special Powers Act, and this heightened the level of security as well as heightened the power and the ability that the armed forces has to control such situations and to ensure that its own people and its own territorial integrity are protected. Thank you.
I want to put the same question which I had put to the other agent. And you were arguing that international covenant, some articles of the international covenant justifies revocation of something which has been granted unilaterally if it is meant for a reasonable cause. So, are you correct in saying so?
Ma'am, the arguments that has been put forward by this agent relate to the human rights.
Basic principle of jurisprudence is that one must be heard. If a right has been conferred on one and it has been enjoyed from time immemorial, while taking it away, he must be heard. Or the state, whoever it may be, must be heard. So, are you justified in submitting that by virtue of an article in the International Covenant, for a reasonable cause, it can be taken away unilaterally?
I would like to answer this question in two prongs. The first prong being the covenant that is being mentioned by the agent, the ICCPR, is one that is binding to 𝚁𝚗𝚞 in the first place, and it is the one which is being relied on the applicant side itself to create obligations. And the general commentary of the covenant as well as the covenant itself provides that certain restrictions can be imposed if the test of reasonability are met. Moreover, the second prong of the argument, which is
restrictions can be, but the party must be heard.
The party must be heard. Moving on to the second part of my argument, it is a generally accepted principle of international law that the domestic remedies that exist when it comes to certain violations have to be first utilized before approaching the international legal order. And the domestic legal structure that exists in the state of 𝚁𝚘𝚞𝚗𝚊𝚜 is quite robust and is quite capable of dealing with such issues. And 𝚁𝚘𝚞𝚗𝚊𝚜 in itself, since it considers the 𝚁𝚘𝚞𝚘𝚗 paradise to be its own integral structure, is very much welcoming to hearing the grievances of the people of 𝚁𝚘𝚘𝚗 paradise. We believe that the claim of the applicants that has been put forth between this bench then stand to be dismissed.
But 1948, you yourself came to the United Nations. You came first.
In 1948, the resolution that is being
Same
mentioned.
issue.
Yes, the UNSC resolution that has been mentioned. May I seek an extension?
Yeah, just half a minute. Somebody else has a question.
𝚁𝚘𝚞𝚗𝚞𝚗 and 𝚁𝚗𝚗, they realized that there was a dispute that was brewing between them, and they approached the United Nations Security Council for the same reason, because it dealt with the United Nations Security Council has the jurisdiction to deal with such matters of instability between states, which is why it then thought it fit to approach the United Nations
All right,
Security
thanks.
Council.
Yes, I put the same question as I put to the previous speaker. Everything revolves around the abrogation of Article 370. The applicant state contention is that it resulted into the gross violation of human rights as recognized by the international law. And your justification is that to maintain your territorial sovereignty, to stop the aggression, the growing militants group, and there's a cleansing of minority from 𝚁𝚘𝚞𝚗 paradise. They are the various factors. But something we need to stand upon our own legs. To justify your abrogation of Article 370 from its operation in one particular state of 𝚁𝚘𝚞𝚗 paradise, what you have done to improve the standard of the people of 𝚁𝚘𝚞𝚗 paradise? Why there was a lot of dissatisfaction because of abrogation of Article 370? If you are able to provide good governance to the people, I think there might not be any dissatisfaction or voice of opposition even immediately after abrogation of Article 370. How you justified your own act? By what you have done, you put the entire blame on the so-called alleged acts of the applicant state. What you have done? What are your justifiable or justiciable acts, both?
To answer the first part of the question, may I seek an extension of a minute?
Yes, within half a minute.
Firstly, the abrogation of 370 and people's dissent to the same does not exist in a vacuum. It is also motivated by political considerations which might be for 𝚁𝚘𝚞𝚗𝚞, which might be against 𝚁𝚁𝚞𝚗𝚞, and this is something which also has to be considered. Secondly, the abrogation of 370 happened after due process, after due thought. It was a policy consideration which came in after the executive felt the need that this is the move which was required to bring 𝚁𝚘𝚞𝚗 paradise to the same standards, to the same rights, to the same levels that exist for the other territories. And since it's thought that Article 370 was an hindrance to achieve the same for the people of 𝚁𝚘𝚞𝚗 paradise, it saw itself fit to take such a measure. If I might seek an extension to state the prayer, if you are